at page 34 to page 39, at 34 to page 45, and impeachment motion was taken out against the previous sitting governor, and more particularly at page 34, may I make a correction, Mr. Speaker, sir, and honorable senators? The impeachment is at page 34 to page 36, not 37, page 34 to 36. It will be noted that those impeachment proceedings of the honorable previous governor that took place on the 14th May 2024, you will see 14th May 2014, 10 years ago. At paragraph 1, the Honorable Speaker then indicated that I wish to notify the members that there is a constitutional requirement and standing orders that for this motion to pass, there should be 2/3 of the members present in the House. So the clerk, before the motion is moved, kindly confirm that we have 32 members. It is clear 10 years ago that the Kericho County Assembly was very clear in its mind that any impeachment or the threshold of 2/3 requires 32 out of 47. I would like to cite another example that happened 2 years ago, and that is at page 37. And I have particular reference to what is contained at page at page 42 of that bundle. At that page 42, Mr. Speaker, sir, and honorable senators, this was the election of a speaker, but not just any speaker, but this specific speaker, Mr. Speaker, sir. And in that discussion also, whether he could take office or not, it was discussed to this effect when it was being presided by the clerk. The clerk said, thank you very much, honorable members. Before we proceed to count the votes, I have very important message to communicate. Please note that the person shall not be elected as a Speaker of the County Assembly unless supported by 2/3 of the members of the County Assembly. 2/3 of 47, we need 32 votes or more. And that if we don't get that, then we'll have to repeat the elections. Mr. Speaker, sir, I would like also to play the audio upon which this specific speaker who presided over these proceedings was elected, and which reflects that 32 votes. I request your IT department to play video number 2. That's not video number 2. Video number 2 is with the speaker. I don't know whether they are playing video number 2 of. Yeah, it is a video where the clerk is presiding over the process of elections, and it is the video submitted by the governor as opposed to the video submitted by the county assembly. Video number 2, please. Mr. Speaker, sir, can I proceed and then we come back to the video when it's found so that we save on time? Yes, yes, Mr. Speaker, sir. I'm sorry, Mr. Speaker, sir, I didn't hear you. Yes, he's gone. He's just left. He's just left, Mr. Speaker, sir. Can I argue the other points and then I come back to it? Yes, thank you very much, Mr. Speaker, sir. So apart from relying on those two instances, the 2014 criteria by Kericho County government, determining that 32 is the required threshold to meet 2/3 for purposes of the impeachment of the predecessor of Honorable Dr. Eric Mutai. Apart from that, and apart from the criteria also applied when the current speaker who approved of this motion also said that it was also decided that 32 MCS required to vote in support to amount to 2/3. I wish to make reference also, Mr. Speaker, sir, to the events of the National Assembly. Mr. Speaker, sir, your colleague, the Honorable Mr. Moses Watengula, in a ruling made on 1st of October, and which I pray, Mr. Speaker, sir, you take judicial notice of, and it was in public domain, discussed the issues that had been raised by a number of MPs, being whether 2/3 is mastered by 116 MPs or 117. And the very relevant bit of that situation, Mr. Speaker, sir, and honorable senators, is that in the National Assembly, 1/3 of the total number of members of the National Assembly, being 349, came to 116.33. And so we find similarity with our case being the 0.3 in that 1.3 is the same as what happened in the National Assembly being 116.3. And the Speaker was very categorical saying that then the 2/3 for purposes of the 1/3 to approve the impeachment motion for the Deputy President would require 117, being that you move a step further. You don't scale down to 116, you scale up to 117. And Mr. Speaker, sir, that ruling by Honorable Moses Watengula is dated 1st of October 2024, and it was in public domain. And we pray, Mr. Speaker, sir, and honorable senators, that the criteria used to elect the Speaker, the criteria used to impeach Honorable Chikpony, the criteria used to consider the impeachment of the Deputy President, I know it hasn't happened, the criteria used to approve the impeachment of the Deputy President at the National Assembly used one formula being that you move a step further because you cannot have a fraction of a person. That criteria should not then change in the case of Eric Mutai and be that you scale down just because it is Eric Mutai, which is our argument that would be discriminatory. The last incident that I wish to cite is the events of Nyamira County government. In that county government, there are 34 members of county assembly. And out of the 34 members of the Nyamira County Assembly, constituted of 15 nominated and 20 elected, the 1/3 was found to be 11.3. We again find the same 31.3, the 0.3 in the case of Nyamira. And in that case, the County Assembly of Nyamira adopted the approach that the 0.3 requires that you scale up to 23 people, as opposed to, 11 people, as opposed to coming back to 10 people. And for that reason, then, Mr. Speaker, sir, I insist that it would be discriminatory to deem the motion that has been brought to this Assembly, to this Senate, as being competent to the extent to which it fell clearly short of 31.3. Mr. Speaker, sir, I am aware that my colleagues are restless to make the argument that this is an issue that does not quite squarely rest on your hands under the provision of Section Rule 30. It is my argument, Mr. Speaker, sir, that it clearly falls within your hands, Mr. Speaker, sir. The said Rule 30 states this, Mr. Speaker, sir, where on a particular question or matter, including but not limited to the question of evidence, materiality, relevance, competency or admissibility of evidence, any question consequential or incidental thereto, where no provision has been made in the standing orders for or in these rules, the Speaker of the Senate shall rule, and your decision will be final. Mr. Speaker, sir, it is my argument that this is an issue that falls squarely in your hands. It is my argument, Mr. Speaker, sir, that when this Rule 14 and 30 was being enacted, they must have contemplated a situation like this, where you need to make a decision on a matter that, as to the competence of this impeachment motion before the senators, on this question of that is consequential as to whether we should go on or not, and all the related aspects of the competence of this impeachment motion. Mr. Speaker, sir, it is my argument that the Senate, in a certain sense, is on trial. It is on trial as to whether it will maintain the requirements of Section 33 on the at least 2/3. And the attendant aspect of the rule of law flowing from whether or not there is observance of that requirement of at least. Mr. Speaker, sir, I will request for just 7 minutes to play the video to make reference to a decision made by Justice Manani, and which is in volume 1, page 60 to page 78. And in that case, Mr. Speaker, sir, the learned judge said that where the committee requiring a certain threshold, in that case it was 1/3, where they sat over a proceeding that fell short of the 1/3, that is at paragraph 90 onwards, then page, I said it is page 60 to page 87, and in more particular, paragraph 90, which is at page 71. At page 71. Where the judge says it is perhaps also necessary to point out that Standing Order 68, subsection 8, uses mandatory term shall when directing that a DOC committee be set up and should comprise 1/3, and then goes on to say if they do not amount to 1/3, then it doesn't meet the threshold. And Mr. Speaker, sir, it is a very significant point that the learned speaker, or rather the Speaker of the County Assembly of Kericho, used that decision, and you will find his reasoning at page 160 to 161 with reference to that case of Michael Ngaduda versus County Assembly of Tana River, and he goes on to say that you round off. And it is our argument, Mr. Speaker, sir, that when you are rounding off, you can never round off to fall below the line. You can never round off to fall to less than 1/3. And if you are to do that, then you would be acting in contravention of the law. Mr. Speaker, sir, with that said, I would pray now to play that video and request, Mr. Speaker, sir, for 5 minutes for my colleague, Mr. Tonen, just to finalize on that issue, on the preliminary objection. Kindly, Mr. Speaker, sir. Mr. Tonen, just to finalize on that issue, on the preliminary.
Yes. Before we proceed to count the votes, I have a very important message to communicate. Honorable members, please note that a person shall not be elected as Speaker of the County Assembly unless supported by votes of 2/3 of all the members of the County Assembly. 2/3 for us, 47. We need to have 32 votes plus, 32 plus. Now, the candidate who in that ballot receives the highest number of votes, and the candidate who in the ballot receives the next highest, in case we don't get the 32, those are the only candidates that we shall go to round 2. Now, when we go to round 2, if they tie, we shall go to round 3. Unless that tie is broken, is when we shall declare the Speaker. Thank you. Now I will ask The sergeant at-arms, please open that thing.
I think that's okay,
Our
Mr.
control
Speaker, sir.
sheet is the number of votes first. We want to count first 47. If they are
Mr. Speaker, sir, that shows the election of the Speaker, who made the arguments that I've just referred to, in which he says, because it's at 1.3, you scale it down, you round it off to the next.
Council for Governor, we've heard the video.
Yes, thank you, Mr. Speaker, sir. Mr. Speaker, sir, then in closing, it is my submission, Mr. Speaker, sir, that there are two issues both yourself and this Honorable Senate need to address. The first issue is what is the meaning of at least in the Section 33 of County Government Act. What is the meaning? And when you apply the calculation in respect to Kericho, does it mean 31.3 and above, or it can be scaled down to 31? So the first issue is what is the meaning of at least in Article 33 of the County Government Act, as read together with Standing Order number 74 of Kericho County Assembly Standing Orders. Number two, the second question, Mr. Speaker, sir, is the question of how do you treat a fraction where it relates to human beings? Are you going to say because it's 0.3, you dismiss it and scale it down to 31, or even 0.3 itself represents a person? And this is very significant, Mr. Speaker, sir. When you look at the situation of these proceedings, being, Mr. Speaker, sir, that there were 47 MCAs in Kericho. 16 said we are not attending, number one. Number two, they said we do not support the motion. The other than 31 were present and they supported the motion. Mr. Speaker, sir, following the tradition of both the Senate and the National Assembly, it is always the case that when members have not voted in favor of, it is deemed that that vote was not in favor of. And so the 16 must be treated as having opposed the motion. It cannot be given conjecture that the 0.3 could exist in the 16, Mr. Speaker, sir. It is my argument, therefore, then, Mr. Speaker, sir, that clearly it didn't meet the threshold. And, Mr. Speaker, sir, I wish to say that considering the precedent from your colleague from the National Assembly, we pray that for purposes of consistency, Mr. Speaker, sir, unless you have a very strong reason to disagree with him, you adopt the reasoning he has applied for consistency and clarity of law. And secondly, Mr. Speaker, sir, that if the criteria is used differently from Nyamira, from National Assembly, from the election of the Speaker, from the impeachment of Honorable Chepkoin, then it would amount to discrimination. Mr. Speaker, sir, I had requested for just a little latitude. I had said 5 minutes. Could you allow him just 2 minutes, Mr. Speaker, sir? Kindly.
Council, your time is up. Your time is up because you kept repeating yourself. Same arguments in different form. So you may want to rest your PO there. Maybe I need to ask you.
Yes, Mr. Speaker, sir.
In response to the preliminary objection raised by, not really an objection, but a preliminary matter from the County Assembly, you have no problem the affidavit dated the 13th of October 2024 be admitted and be part of the record.
I confirm, Mr. Speaker, sir, that I have no objection, and we have discussed both of us, and subject to the Senate and you, Mr. Speaker, sir, we were agreed that they accept our replacement documents properly paginated, and we will have no objection to the
the application for, as far as the witness is concerned?
We strongly object, Mr. Speaker, sir. But as I said, we have this restraint of the order, and we want to be very measured not to seem to be violating the order that we already have in our favor.
Council for the County Assembly, you may now proceed to respond to the PO as raised by the